This lesson will focus on product liability. In this lesson, we will define product liability broadly, discuss the different categories of product defect that could give rise to liability, talk about the causes of action a plaintiff could file if injured by a product, as well as the defenses a defendant could argue, and then discuss the damages that may be awarded if a defendant is found liable. Let's first start by thinking about product liability broadly. In the sport industry, we use sport and athletic equipment heavily in order to deliver our activities and services. As you'll see on this slide, examples of products in the sport industry may include personal athletic equipment that athletes use in their sport activities and competitions. It also may include big, large equipment that is used in sport training, such as fitness equipment or equipment that's affixed to the infrastructure of a sport facility, such as a basketball hoop, an ice rink, could all fall under product liability. Essentially, a product is any tangible property that is used for consumer purposes. Now, a product can give rise to liability if the product caused the consumer injury. And product liability is most often associated with negligence because it is a defect that occurs in the design, manufacturing, marketing, or distribution of the equipment that causes injury. And that consumer is able to receive some type of remedy for that injury. So liability will traditionally remain with the manufacturer, the retailer, the seller, and the supplier, because product liability theory presumes that those individuals are in the best position to become aware of the problems, to eliminate any defects, and to absorb losses from potential litigation because of an injury. On the other hand, participants in sport generally presume that products that they purchase, rent, or use are safe and will enable them to perform in their sport. So the technicality of actually identifying a product defect and addressing that product defect, so the liability for the product defect, will fall with the manufacturer, retailer, and seller. Now, sport managers who supply equipment to athletes, so assign equipment to athletes, rent equipment, can be held liable for defective equipment if they should have known of the defect. Potentially the defect occurred during their storage or maintenance of the equipment. So just be mindful of, even if you are not a part of the design, manufacturing, or marketing of equipment, you can still be liable for injuries that occur due to use of products and equipment that you supply to your patrons. Next, we'll talk about categories of product defect. A product is considered defective under product liability when the defect existed at the time that the product left the defendant. And once again, the defendant is typically the manufacturer, retailer, seller, or distributor. And if that product is defective and causes an injury, then there is potential product liability. So this first type of product defect is a manufacturing defect. A manufacturing defect occurs during the construction of the product. And so when that product is constructed, it is not constructed as was planned or according to the intended design. Rather, there was improper construction of either a part of the product, so just a piece, or there may have been improper assembly of the different parts of the product. So when a defect occurs during the manufacturing process, that defect potentially could occur in all of the products created, or it may occur only in a few random products. It's really just based upon the extent of the construction process, right? And what machines are being used in the construction process. You'll see an example on this slide. There was a game in 2016 versus France and Switzerland. And during this match, there were at least 4 Swiss players who had to go to the sidelines to swap out their jerseys because their jerseys kept getting ripped and torn. Now, the manufacturer of these jerseys was Puma, and Puma said that when investigating and analyzing those torn jerseys, they found that one batch of material had yarns that were damaged during production. So there was one batch of home jerseys that utilized damaged yarns and made the garment weaker, which then caused the jerseys to become torn, which really interfered with the match because the athletes continued to have to swap out their jerseys and they only had a limited number of jerseys. And so this impacted the Swiss players, but Puma, I mean, they manufactured jerseys for Austria, Czech Republic, Italy, Slovakia. So it could have been a much larger issue. However, in this case, the defect was found in just one small batch and had to be amended. Another category of product defect is a design defect. Now, a design defect occurs when foreseeable risks of harm posed by the product really could have been reduced or avoided during the design of the product. Essentially, when designing the product, an alternative design would have created a safer product for the consumer. So the original plans and specifications of the product are considered flawed. A design defect will make all products that are manufactured unreasonably dangerous, not just a few of them. So when a product in its design is manufactured, all of them will become defective. And so all consumers who purchase that product will then be affected, which is often why we see certain products recalled, potentially because of a dangerous design. Now, in this case, the designer is held to the status of an expert in that area. They should know of what specifications are industry standard, what design will create a safe product to enter the marketplace. And when there is an injury that occurs, the courts will utilize a risk utility balancing test. And what they're going to do is they're going to compare the magnitude of the risk that was created by the design of the product compared to the utility of the product. And we'll talk about this again with strict liability, but essentially, if the risk outweighs the utility, and the utility is, the value of the product, the demand for the product, the use of the product. If the risk outweighs that utility, then there is a design defect and there is liability here. An example that you will see on this screen is a case where a plaintiff was climbing on a rock climbing tower and was being belayed by a student using a Trango Jaws belay device. So you'll see that device on this screen. And what happened was the belay device malfunctioned and the plaintiff fell 20 feet and broke his back. Now, the plaintiff asserted a design defect in that Trango Jaws belay device created an unreasonably dangerous product resulting in their injury. Now, the court, when investigating that particular device, found that there actually are other belay devices that will automatically stop the rope in the event of a fall, significantly reducing the risk of injury due to belay or error, because yes, the belayer was a student. The court found that this alternative belay device is reasonable. It would not have created an undue burden on the designer of the Triangle Jaws belay device. So essentially, if a designer could utilize an alternative design to create a safer product, then they would be held liable in this case. And in this case, they were. The third category of product defect is a marketing defect. So this occurs when, because of inadequate instructions or warnings of foreseeable risks of harm when using the product, a consumer is injured. So essentially, instructions and warnings are intended to reduce any potential harm because you are increasing the participants or the user's assumption of risk. You are communicating the qualities of the product. You're communicating the potential risks so they know of the risks when using the product. You're communicating how to use the product. And when you do not provide instructions and warnings and a consumer is injured, there may be a marketing defect, which gives rise to liability. When considering what should be included in the marketing materials of a product, it should include both those instructions and warnings. So the manufacturer should provide the user with just general information about the qualities, characteristics, and intended uses of the product. So the objective of these instructions is for the user to be able to avoid injuries from this information. Adequate instructions on how a product is to be used should be included, as well as information about potential hazards that may occur during use of the product. So these instructions might be: how do you assemble the product? How do you clean the product? How do you inspect it? How should you care and maintain the product? How should you repair the product? All of these would be helpful instructions for a user to protect themselves. The marketing material should also include warnings of any foreseeable dangers based upon not only the use of the product, but also foreseeable misuse of a product. So the objective of a warning is really to alert the user of any danger that they may not be aware of. Now, this warning should be conspicuous, which means it attracts the user's eye. It should be specific so that it can be understood by the user, like by an average person should be able to understand the warning. And it should be forceful in that it convinces the user of the magnitude of the risk. Now, these warnings should be written in a manner that the user recognizes the significance of it and will heed those warnings. Is really important. Basically, anytime a danger is not apparent, it is up to the manufacturer to communicate those dangers to the user. So you have a duty to warn. Now, considering the court system and how they have examined marketing defects, when the danger is absolutely obvious. Now, some courts have ruled that there isn't necessarily a duty to warn, but for the most part, courts have ruled that even when a danger might be considered obvious, that just put a warning on it regardless. So it's the manufacturer, the seller, but also it's the distributor who has a duty to warn. So please note, sport management folks, if you purchase equipment and then assign that equipment, guess what? Often you're taking those instructions and warnings off the products before you rent out the equipment, before you assign that equipment. And it is your responsibility to then convey those instructions and warnings to the users who are using your equipment. So please note your responsibility to inform and pass on those warnings. So you have a duty in this respect to make sure the users are safely utilizing the equipment and using it appropriately. Now, the case that you'll see on this particular screen is in regards to football helmets, which I just find so fascinating, the cases regarding product liability and football helmets. Now, in the 1970s, there's a group known as the National Operating Committee on Standards for Athletic Equipment. So any folks who are interested in becoming an equipment manager or being engaged in the design, manufacturing, and marketing process of equipment, I encourage you to get to know this association. So National Operating Committee on Standards for Athletic Equipment. They established performance standards for football helmets, and they also established what verbiage needs to go on the football helmets. Now, back in the 1970s, they required a warning to be on all helmets. However, this warning was placed inside the helmet. So when it comes to conspicuous, meaning that people can see it, not very effective. But in 1983, the association required the warning to appear on the outside of the helmet, so becoming more conspicuous. And also, as you can see, this warning has evolved over time. So the picture on the right-hand side is the most recent warning on football helmets, which is much more specific and much more forceful. So you can kind of see the evolution of marketing for athletic equipment. Now let's shift to causes of action. So this means that a consumer was injured through use of a product and they want to file a legal complaint to seek a remedy for their injury. There are several different causes of action that the user can, that they can claim. This first one is considered strict liability. Now, strict liability, this occurs when there actually is nothing wrong with the product. So there's no product defect. There's nothing wrong with the design, the manufacturing, or the warning of the product. The product is just considered too dangerous to exist. And so the designer, the manufacturer, and the retailer responsible for creating and distributing this product are just in general liable for putting an unreasonably dangerous product in the marketplace. Now, when a plaintiff claims strict liability, what the courts are going to do is, once again, they're going to use a risk utility balancing test. So we saw this when examining the design defect. So similar type of test in that the courts are going to weigh the danger of the product to the social utility of the product. Because guess what? There are dangerous products out there that people want, right? Fireworks during the 4th of July, try and take those away from Americans. Or guns in Texas, try and take those products away. That is going to be a fight. So courts are going to examine the danger of the product against, so the gravity of the danger, the likelihood of injury, the obviousness of the danger, the ability for the manufacturer to produce an alternative product with an alternative design that's safer. But they're going to compare that to the knowledge of consumers, right? Is it just open and obvious that that's a dangerous product and you need to use it with care? The adequacy of the warnings. You know, if the warnings are, once again, conspicuous, forceful, specific as to warn the consumers of all potential harm and how to safely use the product, well, you know, maybe then that is good enough for that product to be in the marketplace. And then they'll consider the desirability of the product and its usefulness. Does society want that product to be in the marketplace? So those are some considerations that the courts will take to examine a strict liability complaint. Another cause of action is negligence. So this is probably one of the most common causes of action when it comes to product liability, because essentially, if the product is defective in its design, its manufacturing, or its marketing, then what the plaintiff would claim is negligence, because as would be expected, the designer, manufacturer, marketer They're not intentionally trying to injure the plaintiff, but because a defect occurred during their creation of the product, well, they are liable for that, potentially liable for that injury. So it is an unintentional tort. And for a negligence complaint, the courts are going to look at a few things. They're going to examine whether the defect made the product unreasonably dangerous to use. They are going to examine who was involved in the creation of the flawed product. They will also consider whether the product could have been altered. Was there a alternative design or manufacturing product that could have made the product safer? They'll examine the consumer's use of the product. Did they use it as intended? Did they substantially change or alter the product? They didn't assemble it correctly. They didn't maintain it correctly. So they're going to look at how the consumer used the product and if they potentially contributed to their own injury. And then they'll look at, once again, that proximate cause. Did the defect cause the consumer's injury? Now in this graphic, you will see kind of the process when it starts at the designer, then it goes to the manufacturer, the wholesaler, the retailer. Eventually, the product gets to the consumer. And if the consumer claims a defect, then it would be a negligence lawsuit. If the consumer claims that it is just unreasonably dangerous, there is no defect, but this product should not be in the marketplace, then it would go to a strict liability lawsuit. And in this case, just so you know, all members of the distributive chain would be held liable. So that's kind of a unique part, where in negligence is just one member of the distribution chain that would be held liable. Another cause of action is breach of warranty. So warranty is any type of guarantee or promise by the manufacturer, wholesaler, or retailer to the consumer purchasing the product that the product will perform according to industry standards for a particular amount of time. So the warranty is part of the contract between the seller and the buyer. And it's often what the buyer really relies upon when evaluating a product and when purchasing that product. If a breach of warranty occurs, it falls under the Uniform Commercial Code in terms of what information needs to be included in a warranty. Now, there are two different types of warranties. There are express warranties, and then there are implied warranties that consumers just assume. So let's first start off by talking about expressed warranties. Now, in an express warranty that's made by the seller, it is an affirmation of fact or promise regarding the goods. So regarding the description of the goods. In an express warranty, the seller is trying to describe what the product, the quality of the product, how the product should be made, the use of the product, things of that nature. So looking at the example on this slide, here is a Asics shoe, and here's an example of an expressed warranty. Now, often you'll see language such as guarantee, warrant, promise, but it's not necessary, but it just indicates the quality of the product, which you can read here, that how it should be used, how long it should be used for 6 months from your purchase, the warranty will last, and it just gives some additional details about the responsibility of the consumer. Now, in a breach of warranty case, the plaintiff must establish that there is actually an expressed warranty, so a statement that has been made, that statement has been relied upon by the buyer in their purchasing decision, and the product didn't conform to that warranty, right? It didn't perform according to the standards specified for the specific period of time. And because of that breach of warranty, the plaintiff experienced some type of injury. Now, it doesn't have to be a physical injury, it could be an economic injury. So, in the case of a running shoe, if my running shoe blows out in a month, I'm going to be upset that I have to buy new running shoes. And so you could be injured by the product, but also you could experience economic loss if you need to replace the product because it didn't hold up as expected. There are also implied warranties that exist at the time that the buyer purchases the product from the seller. So when you're purchasing a product, you're assuming that the product is going to be used for its intended purpose, that it's fit for its intended use, that it is as described, right? You're just assuming that the product um, meets, industry standards, that it's appropriate for its intended use. You just make those assumptions when you're purchasing a product. And so there are two different categories of implied warranties. There's implied warranty of merchantability and there's implied warranty of fitness. Once again, these are assumptions that a buyer makes when purchasing a product. Now, the implied warranty of merchantability is all about the quality of the product. And this is a presumption that the product is of average grade, quality, value, that it's similar to other products that are sold in the marketplace under similar circumstances. So it is of good average quality. Now, a product will meet this implied warranty of merchantability if it, would pass under under inspection, if it is of fair average quality, if it is fit for its intended purposes, if it does conform to the promises that are made by the seller and the manufacturer. And then there is also an implied warranty of fitness, and this is an assumption that the product is fit for its intended purposes, right? So you should be able to use a basketball in the sport of basketball, that you should be able to use that product for the specific period of time. And in this particular case, sometimes warranty of fitness is actually included in the express warranty. And sometimes this warranty of merchantability will also be expressed, as you saw on the previous slide with the ASICS shoe, in the description of the goods and how the goods should be used for how long. You may see some language that relates to merchantability and fitness, but it's just an indication that there are certain promises that a buyer will presume upon purchasing a product. And then a couple of other causes of action that a plaintiff can file if injured by a product. One is misrepresentation. I love this picture on this slide because it's so true. I feel like commercials always misrepresent food, and then it makes me hungry. And then I go to the restaurant and I get disappointed. But misrepresentation is essentially an inaccurate statement that leads another person to believe that this inaccurate statement is true, and it influences your purchasing behaviors. Now, in this case, the product, it doesn't need to be defective or unreasonably dangerous. It just needs to be like falsely advertised, which influenced your decision. In misrepresentation, when it comes to a product liability complaint, the claim does need to include physical injury, though. That was one clarification that I wanted to make note. So while the product doesn't need to be defective, if a product is misrepresented, which influences a buyer to purchase that product, and then that consumer becomes physically injured, they can claim misrepresentation even if the product isn't defective, isn't unreasonably dangerous, but guess what? They were influenced to purchase the product and that product happened to injure them. So for sport managers, you really just need to be careful when you're advertising or selling a product, in your either expressed comments verbally or in writing or over the phone or the internet. just make sure to represent products accurately is important. And then another cause of action, it relates to the Consumer Product Safety Act. So the National Commission on Product Safety is a governmental administration that explored the need for federal regulation of consumer products. And this group established the Consumer Product Safety Act, which you can see the purposes on the slide are to protect consumers against unreasonably dangerous products, to help consumers evaluate products in comparison to other products in the marketplace. It develops safety standards for products that are standards that the designer and manufacturer must adhere to. And it also promotes investigation into the potential causes and prevention of product related like deaths and injuries. So I find it really fascinating, and it's a act that can be brought up in a legal complaint. The CPSA requires manufacturers, if you ever come across a product defect, you do have to report it to the National Commission on Product Safety. You have to recall products. So this commission recalls over 200 products every year. And most of these recalls are voluntary because the manufacturer informed them of a product defect and they're doing their due diligence, their responsibility to keep their consumers safe. The CPSA also maintains a national electronic injury surveillance system, which is a long way to say that they gather all information from hospitals related to any injuries associated with consumer products so that that information can be used to investigate potential product defects as well. It's a really great act. Now, those are all the different causes of action that a plaintiff can bring. In response, there are a few defenses that a defendant can use. So in this case, once again, the defendant is either the designer, manufacturer, retailer, seller, or distributor of the product. One of the most common defenses is assumption of risk. An assumption of risk is something that is recognized in most product liability situations. So assumption of risk that the plaintiff knew of the risk of danger when using that product, or they should have known of the risk of the danger. For a defendant to claim assumption of risk, the consumer must actually be aware of the danger, be able to appreciate the significance and magnitude of the danger, and then voluntarily assume that danger by using the product. So knowledge of the risk is key here. And you'll see the example on this slide with REI. In their equipment rental agreements, they always include assumptions of risk. So this is an equipment rental agreement for bicycles. And what's great is that it not only talks about how to use a bicycle, right? Like look at highway traffic regulations. I love it. Proper use of equipment. It's talking about how to safely use the product, but in the assumption of risk, it is recognizing that there are known dangers and hazards when you are using a bicycle. It might be mechanical failure, right? It might be that you lose your balance and you fall over. It might be collision. And so they're outlining some of the major risks associated with use of the product. And typically that assumption of risk is then going to be tied into a waiver where REI is releasing their company of liability and the consumer is relinquishing their rights to file a lawsuit in exchange for the right to use the equipment. So with assumption of risk, make sure to educate your consumer on the dangers so that they are knowingly and voluntarily assuming those risks. Now, when you're working with elite athletes, for example, often it is anticipated that they are aware of the dangers of the sport and the athletic equipment that they use. However, when you are working with younger populations that lack capacity, you really need to inform them of those risks. Another defense that is commonly used is contributory negligence, which essentially means that the user, so the plaintiff, contributed to their own injury through their use of the equipment. So this can come into play in so many different ways. The user may have ignored the warranty, ignored the instructions on how to assemble the equipment, how to use the equipment. They may have ignored all of the warnings about the potential risks of the equipment. They may have used the product in a really unusual way, as you will see the pictures on this slide. If you can't tell, that is a Segway on a treadmill, which seems like it defeats the purpose, but maybe that's just me. So those are all different examples of contributory negligence when the plaintiff may have contributed to their own injury and therefore should be liable, if at least partially liable for their injury. And then misuse also kind of wraps into contributory negligence, because if the consumer misuses the product, so that means that the product is not used for its intended purpose, what was envisioned by the designer and the manufacturer when they created that product. Well, in that case, that may bar recovery from the plaintiff. So if the plaintiff mishandles it, abuses it, uses it for really abnormal purposes, in this case, that can be a really great defense for the designer and the manufacturer, particularly if, the manufacturer in their marketing, so in their instructions and warnings, if you instructed the consumer on exactly how the product is to be used, and if you warned the consumer of all of the dangers of misusing the product, well, in this case, you're really protecting yourself from liability. So once again, for sport managers, if you are renting equipment or if you are assigning equipment to athletes, just please make sure that you are instructing those consumers on how to appropriately and safely use the product for its intended purposes, just to make sure that you're protecting yourself from liability. And then here is another defense that the defendant can use is a disclaimer. So a disclaimer is a defense against a breach of warranty lawsuit, just so you know. And a disclaimer should be placed usually in the packaging, so the marketing of the product. And a disclaimer, it's almost like a waiver. So I think of disclaimers often when I think of like going to a baseball game, the disclaimer on the back of the ticket that says like, enter at your own risk type of thing. Like they're flying balls, they're flying bats, you may get injured, but we are not going to be held responsible or liable. A disclaimer is different from a waiver because in a waiver, you actually have to sign a waiver. It is a formal contract. Now, a disclaimer is not a contract because you are not signing anything, agreeing to relinquish your rights to file a lawsuit. You are not agreeing to the statement that the manufacturer is not liable. However, a disclaimer, so it's not a contract, but it can be a viable defense in that it continues to express, warnings, instructions. It provides information about the quality of the product, how it should be used. So it's kind of building up those other defenses. So a disclaimer is stating that the manufacturer is not responsible or liable for the product if the product is used for a purpose that is either beyond the limits of the product, if it's used for a purpose other than is what is recommended. So a disclaimer goes hand in hand with misuse. So basically, they're not liable if you use this product improperly. And you'll see the example on this slide. I actually have this product. It is a clip that will attach to the back of your shoe and it lights up. So it's great if you're ever walking or running outside at night. And in this product, you'll see the disclaimer that there is no liability or responsibility for accidents or injuries to person or property that may result from the improper use of the product. So once again, disclaimers heavily associate with misuse. And it's just blanket statement. Use it appropriately or else you're going to be liable. And similar to a warranty, similar to marketing, disclaimers must be conspicuous. So you must be able to find it. must be unambiguous and clear. So specific, easy to understand. Now, in a product liability lawsuit, if the defendant is found liable, right, it could be for misrepresentation, it could be for product defect, so design, marketing, manufacturing defect, or just strict liability. You put a super dangerous product in the marketplace. In this case, the courts can provide a remedy in the form of monetary damages to the injured party to make them whole again. Now, these are damages we have discussed in previous lessons, but they are essentially compensatory damages or punitive damages. Compensatory damages are most common in product liability cases where the damages reflect the expenses directly involved in the injury and rehabilitation of the plaintiff. Now, punitive damages, so this is less common in product liability, but a couple of examples when they may be awarded is when let's see, if there was prior knowledge of the defective condition of a product and there was failure to do anything, right? The manufacturer knows there's a product defect and they don't recall the product. That's a big issue. A distributor, so support manager, assigns a product that you know is damaged, that you know is defective, and someone gets injured. That's pretty reckless. So if you have knowledge of defective condition and you don't do anything, that may result in punitive damages. Also, if you fail to inspect or test your products, right? A designer, you are responsible for creating a prototype, testing the product, making sure that it's safe, making sure there aren't any alternative designs that would make a product safer. If you don't take those important steps, you could potentially, be liable for punitive damages. Or for those who are maintaining products. So equipment managers, if you're not maintaining them properly, if you fail to inspect the products regularly, if you fail to get the products, tested, checked, you could potentially be liable for punitive damages. So just to be mindful of the fact that recklessness can give rise to punitive damages. And that is what we have for product liability.